Good morning, everyone. So first of all, I just wanted to run through the agenda with you. So I'm just going to give you a brief update of where we are in our conversations with government. Then we're going to talk through impact on movement of goods, so customs, some VAT issues you should be aware of, some very brief direct tax considerations before we wrap up with some Q&A. Hopefully we'll be able to answer most of the questions that you have with regards to practical issues that you need to resolve leading up to Brexit Day on the 31st of October. So your speakers today, you're listening to Stuart Lyle at the moment. I'm the co-chair of our Brexit task force and a tax partner. I'll be joined by Håkan Henningsson, Customs Duty Director with many years of experience. He's going to be working with Juliet Walbrook, another Customs Duty Director, again with 15 years of experience, and completing the team, Glyn Woodhouse, who is an indirect tax partner in our Reading office, meeting our team in South England. So, Brexit preparedness. I was actually in a meeting with DEXU on Friday, and they are very keen to work with businesses and the advisory community to ensure that businesses are ready for Brexit. Now, people may think that's a little bit late in the day, but they're now obviously driving this agenda forward. As they see, it's so key to the economy that businesses are as ready as they can be. So I said, we're meeting with them regularly now to assist them. We're part of their business advisory network and working with a number of intermediaries. So they have chosen a group of intermediaries across the various sectors to work with supply chains and advise on issues, and also to spread the government word as to how things should be moved forward. Their key message to us when we met them on Friday was that businesses should be prepared for leaving the EU on the 31st of October with or without a deal. And they were keen to point out that whatever planning we do and businesses do for a no-deal exit should put them in good stead for any exit with a deal scenario also. Interestingly, they are looking very hard at easements to help businesses with some of the various issues that Håkan and Juliet will talk about, some of the issues we've seen with applying for various of the customs and VAT reliefs, to try and make it easier for business to be ready running up to 31st of October. If you've gone on to our Brexit Hub, you'll see that we've updated it with 10 immediate actions. These are things that we considered as being key things that could be done in the short term to ensure that you're ready for Brexit. So things like making sure cash movements are carried out before 31st October if possible, knowing your customs duty rates, and it may mean actually that post 31st of October may be better than pre 31st of October with the new emergency tariffs that have been issued by the government. Checking your data transfer and protection obligations, looking at your contractual terms, and stocking up to help manage transport delays. So all practical things that you should be looking at now, ready for the exit day in 7 weeks' time. I'm now going to hand over to Juliet to talk about customs duty.
Thank you, Stuart. Good morning, everyone. Myself and my colleague Håkan are going to talk you through the key points that we've identified when dealing with other clients and other companies which are going to impact the movement of goods post-Brexit. So for companies and their supply chain, they're really going to be facing two main costs. There's the immediate cost, which I think everyone thinks about, which is the imposition of tariffs between the UK and the EU. And there's also the administrative costs that will come into play regarding customs declarations. So I'm going to start off by talking through those two issues first, and then Håkan, my colleague, will give some insight onto potential solutions. So with tariffs, it's not 100% straightforward. We have to consider two different scenarios. If you're talking about goods moving from the EU to the UK, as Stuart mentioned earlier, the government did issue a temporary UK customs tariff shortly before we were due to leave at the end of March earlier this year. Now, the good news with this tariff is that the duty rates on, I think, over 80% of goods have been removed. A note of caution, though, this tariff is temporary, only in place for 12 months, and import VAT will still be applicable, so there will still be a cash flow implication. Those temporary tariffs are only EU, UK inbound. For those companies that send goods from the UK to the EU, there will still be tariffs to be considered, and those will be the same tariffs which are currently applicable rest of the world into the EU. So just because the payment's slightly easier one way, it's not the same both ways. Regardless of whether we have a no deal or a deal, customs declarations are also going to be required when goods leave the UK and enter the EU, and vice versa. There will be a cost attached to this as well. And the cost for a customs declaration, bear in mind, is per consignment. It's not linked to the value of the goods, it's the number of times, it's every time a customs declaration is submitted. Now, there are two ways of doing customs declarations. The vast majority of companies employ a freight forwarder. The freight forwarder submits the declaration on behalf of either the importer or the exporter. Rates for doing that declaration process vary. At the moment, they're anywhere between £30 and £50. We are hearing stories, rumours that cost will go up because we'd be in a supply and demand market. So for companies that are making lots of supplies, even though they're not necessarily high value, this is probably going to be more of a relevant cost to you than any tariffs. So be aware of that. Obviously, the two work together, and we hear, again, concerns, stories that there will be delays at border. Nobody knows what will actually happen. A lot of focus has been given by the government to ease the process from EU into the UK. Possibly more of a concern is goods moving from the UK to the EU. We have already heard that certain customs authorities in the EU, such as the French, have given the clear message that unless the information in those declarations is correct, they will not allow the containers to move. So companies really need to make sure that they've got on top of that. I'm now going to hand over to Håkan, and he's going to talk about some of the solutions that could potentially address these issues.
Thanks, Juliet. Yeah, so as you might have said, spotted there in the slides, we talk about actionable insights, and it's because that not all of these issues can be easily resolved, but it's important to be aware of the issues and what effects they will have on your particular business situation. So follow up on what Juliet was saying. I will talk first about the actionable insight on tariffs. Now, we always say to our clients that the first thing really to do when looking at what tariffs might be applicable is to have a broad look at the goods movements in and out of the UK. And also, of course, you need to look at what are the duty rates for those products. Duty rates differ, as Juliet said, for many products going into the UK. The proposed temporary tariff is going to have a zero duty rate, but other goods have a positive duty rate. So it's important to figure out what goods are moving into the UK and out of the UK. And secondly, what commodity codes do these goods attract? What commodity codes apply to these products? Because that is what will determine what the duty rate will be. It will be a matter of clarifying what are the commodity codes. That is something that many companies have been consciously doing for goods coming from the rest of the world into the UK, but not necessarily so much for companies that only have been moving goods from the EU into the UK. There's been many times, of course, a trade statistics requirement, Intrastat, ESA sales list, etc. But it will become even more crucial to get the correct duty rates applied to your goods. So identifying the correct commodity code is important and is directly linked to the cost for tariffs. Now, what can you do then once you have identified that you do have substantial costs for the tariffs? Well, there are a couple of things that you then can look at. For one thing, you need to look at are there perhaps any preferential duty rates applicable to your products? And that has to do with free trade agreements and imports from developing countries. But also duty reliefs to have a look at, which could reduce your duty cost. And that are things like we mentioned here about customs warehouse, inward processing. Those reliefs are in place today in the EU, and the UK will apply the same duty reliefs under the UK customs law that would come in place in a no-deal scenario. So those reliefs will allow you to, in certain circumstances and under, of course, assuming that you meet the requirements, will allow you to reduce the duty cost. Now, that's something that needs to be looked at very carefully on a situation-by-situation basis, and that's something that we've been busy doing with our clients for a longer time. Of course, prior to Brexit, this is still important and relevant for many companies, but we would argue that after Brexit, that will become even more important to be aware of the potential reliefs and what you need to do to apply for them and meet the qualification criteria. So that's about the tariffs. If we move on to the second group of costs, as Juliet mentioned, we talked about the customs declarations, and Juliet already mentioned that, well, normally you would have an agent who makes the declaration and they will charge you for it. Alternative, again, as Juliet said, is that you do it in-house. That means that you're not paying a third party some kind of service fee, but you will also have other costs, so primarily costs associated to staffing and training. And there's also software to consider, because to be able to make a customs declaration, you need to be linked with HMRC's declaration system, so there's software issues, or rather the software is required to be able to make those declarations. So that's important to have a look at that and make a cost-benefit analysis of should you make the declarations in-house or should you outsource that task. And again, as Julia said, it's important to stress, even if you would outsource the task, HMRC will still hold you responsible for the correctness of the declaration made in your name. There's one thing that is rather interesting, and it's something called an EORI number, EORI number. Many of you on the call probably know what that is, but just briefly, it is a reference number that the customs authorities have, similar to VAT number, but it is not a VAT number. The EORI number is what is quoted on the customs declaration. So you do need to have an EORI number in order to import goods into the UK. If you're a UK company, you most likely already have an EORI number, and if you haven't had it before, you most likely have had an EORI number auto-issued to you in the last couple of weeks by HMRC. So that's a precaution. HMRC knows that you do need to have the EORI number rather than realize that on day one. It's better to have that in place already now. An interesting thing is, of course, when you want to export something from the UK, you will use your your UK EORI number for the export declaration. But if you have taken on the responsibility to be the importer in the EU, then you also need to have an EU EORI number. So you need to have two EORI numbers, one for the export declaration and one for the EU import declaration. We will talk later about the Incoterms and under what circumstances you or your trade partner is going to be the importer and exporter respectively. But it's interesting, Stuart had some good news from the government. Of course, there are many EU companies who today are bringing goods into the UK and are responsible for that in their customer contracts. So an EU company would have an EU EOR number which would not be valid for a UK import declaration. That creates a bit of a catch-22 situation because legally you can only have one EOR number per legal entity. So HMRC is looking to ways to try to facilitate that and make it easier for an EU established business to acquire a UK EOR number prior to no-deal Brexit. It may not be issued before the 1st of November, but at least they're looking to try to speed up the process so that the waiting time will be shortened. So I think the last thing to mention on the point about customs declarations is that if you decide to go in-house and make them yourself rather than having an agent doing them, then you do need to have training. Completing customs declaration is a complex task. It is something that requires that you're being trained by someone who knows what they're doing rather than having read a book about it. And we do have people in our team who have provided training on how to actually complete customs declarations. So we are happy to help with that. There's also a grant scheme that HMRC has issued. So it's possible to get some or all of those costs for the training reimbursed by HMRC. Finally, just looking at the delays at the border, and one thing that the government has done to try to mitigate any delays on the inbound into the UK is that they've issued a program called TSP, Transitional Simplified Procedures. And what it means is that if you are registered for TSP, then you're able to move the goods into the UK without making a full customs declaration already when the goods come into the country. So you're able to postpone making the full declaration, and you also then, which is rather handy, you're also not having to pay the customs duty at the time that the goods arrive in the country, but you pay the customs duty when you make the full declaration later. Now the TSP is really intended for trying to ease the potential bottlenecks at the ports so that the goods can move freely into the country. But it's important to keep in mind that it's not going to do anything about the goods going out of the UK. TSP is merely looking at the UK imports. It's a simple procedure to register for TSP. You don't need to apply for it, and there's no processing time really from HMRC's side. So we think that that's a good idea to do. You can always decide later whether you want to make use of that facility or not. There is no harm in registering for TSP. One thing to be aware of though, and that's not entirely clear sometimes from the communication from HMRC, is that to be able to use TSP, you do need to have a deferment account. Either your own deferment account or you need to use someone else's deferment account, such as a freight forwarder. And attached to the deferment account, there must be a guarantee for the suspended customs duties. So that's something to keep in mind. And the guarantee post 1st of November, HMRC has confirmed in discussions with us, does not need to be a customs comprehensive guarantee, but it can be any form of financial security that allows HMRC to recover the customs duties if the importer is not meeting their obligations. Finally, I should just mention about delays at the border. We talked many times about AEO with our clients, authorized economic operator. That is not the same as TSP. It's a completely different relief. AO has been around for a long time and will continue to be important, but AO is really intended for goods that are coming from outside the EU, while TSP is only eligible for goods that start their journey in the EU territory. So I think we'll move on to the next slide, and Juliette will talk about two other areas where the movement of goods are impacted by Brexit.
Thank you, Håkan. One of the key areas that has led to discussion with clients and companies when we've been talking about this is Incoterms, and I can't stress how important this is, particularly for those companies that have up until now or have a predominantly EU supply chain. So Incoterms briefly are a set of standardized terms which determine when the responsibility and the risk for moving goods passes between two parties. It's not legal title, it's the movement of the goods. Now there's various Incoterms you can have depending on when you want that responsibility and that risk to transfer. The reason why this is important is because for a lot of companies that have EU supply chains, in their contractual terms with their suppliers and their customers, they may have Incoterms in there, they may not. They may have different Incoterms for different business partners, but they probably haven't looked at them. Because for goods at the moment that move between EU member states, Incoterms don't really have much relevance. But they will do post-Brexit because the Incoterm will determine which one of those parties has responsibility for paying the tariffs, making the customs declarations. And as Håkan said, even if you use a third party, like a freight forwarder, to do the declarations, it's you as the importer or the exporter who is legally responsible for the accuracy of that information. So what does this mean in practice? To give you two examples, if you are a UK manufacturer and you are buying materials on an ex-works basis from an EU supplier, and if this is already in your contract with your supplier, what ex-works means is that you then are responsible for the export declaration in that EU country, the freight, the import declaration in the UK. It's not your supplier's responsibility, it's yours. There's a quirk of EU legislation as well that says you cannot be an exporter in the EU unless you are established there. So if you're a UK company with no establishment in the EU and you've currently got an Incoterm where you're buying ex-works from your supplier, then this is going to be challenging. Likewise, if you are selling to customers in the EU and you're currently selling on a delivery duty paid or DDP basis, you are responsible for the export declaration from the UK, the freight, and then the import declaration into the EU. So whilst these situations are surmountable, they are not straightforward. And if you do have any examples, then you need to be considering what you can do about this at the moment. Also aligned to this, depending on your Incoterms, comes requirements for VAT registration. So, for example, if you are making a sale into an EU country, there may well be VAT registration requirements there which you need to consider, which you haven't needed to consider to date. So this is the one area, whenever we have spoken to clients and we've spoken to companies on Brexit, that has caused the most problems. So I strongly recommend go and have a look at this now. Final point to cover from the impact side of things is imports and export licenses. We've talked about tariff, we've talked about duty. But bear in mind, when goods move cross-border as well, sometimes there are other related licenses which need to be produced, like foodstuffs, drugs, pharmaceuticals, of course, because we've been in the EU, we are in the EU. A lot of these requirements don't currently apply, but once we leave and we become a third country, they will. So we'll see more onerous requirements in place about licenses. So I'm just going to pass back to Håkan now, and he'll talk about a couple of solutions.
Yeah, so as Juliet said, one problem that many companies face is that suppliers in the EU, there's never been a real need to determine who should be responsible for exports and imports between the two parties, the suppliers in the EU and the importer or the customer, your company in the UK. There's been no need for that simply because the EU doesn't have any internal customs borders, so there's no need for a customs declaration when goods move within the EU. So that will change, of course, if you have a no deal on the 1st of November, and there will be need for the customs declaration, and someone will need to do that. Now, as Juliet said, if you have an ex-works terms supplier in the EU, then that's something that you do need to deal with, because if you're not, then the goods will not move on to you into the UK after the 1st of November. So if you're not established in the EU, then you cannot submit that export declaration. So you need to talk to your suppliers. Either you need to establish yourself in the EU, and then you can be an exporter out of the EU, or you need to have someone else who's making that EU export declaration and take responsibility for that. That's obviously a tricky question, and it's more a commercial question than a customs technical question. And we encourage companies to talk to their suppliers, and likewise if you have EU customers that you deliver duty delivered paid terms to. That is a discussion that's better to have sooner rather than later, because it's not a problem that will go away if we have a no deal. It will need to be dealt with. Glenn will talk later more about the VAT side and things like VAT registrations, etc. But as Juliet said, keep in mind that the customs and VAT is often linked when it comes to scenario planning like this. So what can you do? Setting up an EU establishment solution, or short of that, perhaps just have an EU VAT registration. Many different things to consider. And this links really to the last point that I would like to make on that slide. We talk about video Brexit workshop. It's not only for looking at things like import and export licenses, commodity codes, delays at the border, what effects it will have. It's also very much about mapping your supply chain and looking concretely to what you need to do in preparation for 1st of November. There's of course the possibility that we will not have a hard Brexit and no deal Brexit on 1st of November, but you do need to plan for that possibility. Just finally, when it comes to the licenses, as Julia said, that's really important. And some licenses that have not been required while the UK is a member state will be required going forward. So that is not something that you can mitigate. It is a legal requirement. It will be a legal requirement, but awareness of it and discussions with your trade partners, your customers and your suppliers is crucial. So these kind of half-day, whole-day workshops that we hold with our clients is really useful to map out all the different considerations, both from a customs and from a VAT point of view. So I think that's kind of a good intro to Glyn and the section about VAT.
Great, thank you Håkan, thank you Juliet. Some really interesting points there. I think there's 2 points that I would make before I launch into a very brief piece of VAT. Firstly, is that the VAT comments I'm making are very limited to a couple of scenarios and are not in any way sort of complete. And you need to think more widely on the VAT side, particularly if you are involved in trading securities, or you are a tour operator, or any of those specialist areas. The second point, I think, is on the back of Håkan's comments, it's really important to get together the different strands that are going to apply to your business post-Brexit. It's very, very easy to say, oh, we'll set up an establishment in the European Union, but of course that will have knock-on consequences for VAT, it'll have knock-on consequences for transfer pricing, and it'll have knock-on consequences for direct taxes potentially, and whatever direct tax arrangements you've got in place already. So it's important that we look at this holistically, and we try and involve all the taxes as far as we can go. So I'm going to talk predominantly today about VAT registration issues, because that is one of those areas which is causing the most immediate thing. It's relatively simple, but the VAT registration is going to be driven by who is the importer and what happens to the goods once they're imported. So for goods coming into the UK, goods being imported, if you are the importer into the UK, and you sell those goods cleared in the UK, then you are likely to have a VAT registration requirement. And that goes the same for your supply chain. So if your supplier is saying, okay guys, I'll arrange for the import declaration and I'll be the importer, that's okay, that's great, but you need to remind them that they will then need to clear those goods into the UK and account for VAT on that onward sale to you. Otherwise, the VAT that will be incurred on import, even though the VAT is now going to be on deferred accounting, so there won't be a cash flow impact, it will only be able to be recovered if you're VAT registered. And this, of course, works the other way round. So if you have a distribution arrangement, which means you're taking goods, delivering them to customers in the EU, at the moment, post-Brexit, those goods will be imported into the European Union, and that onward sale is most likely going to give rise to a VAT registration requirement. Now that can be tremendously difficult if you have multiple different countries with customers in them. You can end up with up to 27, 26 now, VAT registrations across Europe. The other point I would make very, very briefly on that is that goes for all movements of goods. You also need to consider things not just on sales and purchases, but on things like supply and install, on repair stock, and goods returned for repair. So the other thing on registration is, of course, that we will end up losing the so-called EU simplifications that prevent a business having to register in multiple member states. Now, those of you familiar with VAT will know that there's a call-off stock one. That happens if you own stock in an EU member state which is gradually drawn down by your customer. That enables you to get out of the VAT registration. Supply and install, where you take goods into Europe and you install them into a client site. Both those scenarios are now going to give rise to a VAT registration. The other one that I just briefly wanted to mention, because people tend to see it slightly more complicated and therefore have a little bit of a blind spot on it, is triangulation. If you are supplying goods in the European Union and you're sourcing those goods in the European Union, so for example, you're buying goods in France for delivery to your customer in Germany, then that will give rise to a VAT registration now. The old triangulation only works with 3 EU countries and 3 EU VAT numbers. If you're not registered in another EU member state, you need to look at that quite urgently and try and work out what the best solution is for you, as with the other one. So finally, moving on, if you are already registered for VAT in Europe, remember that registration rules are occasionally different for non-EU businesses and EU businesses. If you have a VAT registration overseas, do check with your advisors overseas to make sure that your requirements aren't going to change and you don't need to change your VAT registration. That can be particularly a point with some countries, for example Portugal and Belgium actually, where they normally require a fiscal representative to be appointed for anybody VAT registered over there. And that means that somebody locally is going to have to be a local citizen and will stand jointly and severally liable for any VAT debts that arise in that country. If that's the case, obviously you need to find somebody to be a fiscal rep, and that can take some time, and it can also be costly. So, actionable insight. Do check your supply chains. And by supply chains, I can't emphasise strongly enough, it's not just sales and purchases, it's all your movement of goods. It's movement of stock, it's movement of goods, it's return stock, it's all that stuff. In particular, check who's going to be the importer and whether you're relying on any of the EU simplifications. If it does rely on the simplification, can you just change the contract terms? Bearing in mind, once again, that may have direct tax consequences and may have customs consequences. And if you have a VAT registration, do check that the circumstances won't change. So finally, very, very quickly, for those selling business consumer, all sales of goods to individuals, instead of being supplied effectively from the UK and subject to the distance selling rules under UK VAT, import VAT and duty will potentially be payable on those movements. If you don't take any arrangements for the settlement of the tax, then the individual buying your goods is going to be liable. They'll have to go to the post office and pay the VAT and the duty. There are also a whole heap of new changes being proposed by the EU on low-value consignment relief and the new mini one-stop shop. But I don't think there's much benefit to me going in huge details now, because I think we'll get far more benefit out of the questions that you raised. So without taking any more time, I'll hand over to Stuart. Talk about direct tax.
Thank you, Glyn. Hello again. Blimey, the indirect tax issues are much greater, more complex than anything I'm going to talk to you about in relation to direct tax. There's just a couple of things I wanted to just make sure people were aware of and were on their agendas. So, first of all, we currently benefit from the various directives in the EU with regards to passing profits around a group in the form of royalties, interest and dividends. And under the group directives, we are not required to withhold tax from payments we make to EU members of the group, or for that matter for those members to withhold when they pay to us. Now, when we come out of the European Union, those directives will cease to apply, and so we do have a risk of increased withholding tax issues within the group. So what HMRC have done is they have made an announcement back in May saying that they will continue the benefits of that directive for outward payments from the UK when we leave the EU, although you'll still need to apply for permission to not withhold from interest, although they will not apply to royalties, and of course we don't have withholding on dividends. There's been no such comment from the EU, so we need to think about whether there'll be withholding tax on flows of profits coming through the group from the EU. So, two things to look at. Firstly, look at the double tax treaties that are still there and are still in force from prior to the directives. There are 10 countries of the 27 where we can reduce withholding taxes down to zero, but there are obviously many that we can't. So you need to have a look at the countries where you do have EU subsidiaries and consider the withholding tax implications. Or also whether you need to do a group restructuring where you have an EU sub-holding company with all the EU companies underneath it, all of which will benefit from the directive, and providing you choose that company in the right jurisdiction with the right double tax treatment treaty between it and the UK, then you should be back in the same position that we were before. But certainly something that needs to be looked at, but not as urgently as when you're moving goods and services across borders. Transfer pricing is an interesting one. Obviously, we've seen a significant devaluation of sterling over the last 3 years, and we are seeing that this is having an impact on a number of clients' transfer pricing where everything was calculated on a certain exchange rate, and obviously that's changed dramatically since then. And something which is not really not really direct tax, but something that I want to mention again, and it came up in the conversations I've had with the government, which is in relation to day one trading and making sure that UK companies that are going to trade in the EU, not only do they have the right VAT registrations and they've got their customs duties right, etc., but they actually have the right licenses in place to be able to trade in those EU countries. An easy one to oversee, to miss out when you are worried about all your indirect tax consequences, but an important one nonetheless. Just a quick note of things to help you stay informed. As I mentioned at the beginning, we have a list of 10 immediate actions that we have posted onto our Brexit hub, which can be found at bdo.co.uk/Brexit. We're just about to post an update of our detailed planning guide on there as well. And also, to stay in touch with our tax specialists, please join our LinkedIn group on Top of Tax, where we post regularly updates on Brexit-related issues and other general tax issues for you to be aware of. So now time for questions. So we've had a couple of questions come through from people whilst they've been listening to the webinar. So I'm going to read out these because these are aimed at my indirect tax expert colleagues. The first one is to do with the ORI number, and I think Håkan can answer this. Does this apply to supply of only physical goods? For example, a UK software company contracting with an EU legal entity for licensing, would they require an ORI number?
No, the EOR number is only used for a customs declaration, and there's no customs declaration needed for software, for downloading your software. So unless you're actually physically shipping a hardware with the software uploaded on it, then there's no need for an EOR number.
One little addition on the backside there, though, is because of the use and enjoyment provisions which apply to certain supplies of electronic services. If those are electronic services, of course, don't forget that the UK then will be a non-EU entity, and that will have an impact on the valuation issue.
Thank you. Are EORI numbers for importers only? Would it apply to a services company that wants to bring something to the UK?
So again, your number is needed for physical goods movements, where you need to have a customs declaration. But if it's a provision of services or downloading of software on the internet, then there's no EOR number needed.
So if it's a services company that want to import new office furniture, for example?
Yeah, then they do need to have an EOR number. So if they want to import, office furniture, IT infrastructures or hardware, then they do need to have an EOR number,
Okay, thank you. A question, won't it be a struggle with the Incoterms changing in 2020, not long after Brexit?
Yes, it will. There are expected to be some changes because Incoterms change every 10 years. But again, I think that just reiterates our point about understand what your contractual terms are with your suppliers and customers, and make sure that those are what you want and as far as possible, the most commercially beneficial to you.
Okay.
I think something worth keeping in mind too is that Incoterms is not something that is legally required. Incoterms are meant for easing trade and make the rules around who's responsible and who has the cost for various tasks relating to the supply chain. That's what they're there for. So there's no requirement to use any particular Incoterms. And as Julia said, as long as
commercial decision, isn't it?
yeah, as long as the supplier and the buyer are in agreement about who's doing what, that is really what Incoterms are about. So yeah, there might be some initial confusion when the new Incoterms are being used, but it's nothing that has to do directly with Brexit.
Okay. Somebody's asked if they have some EU VAT claims outstanding, and will these still be able to be recovered post-Brexit, or is this going to prove difficult?
They should be recoverable post-Brexit. Obviously, the UK may not be as popular as it has been historically with certain member states, particularly if there is a predicted slowdown across Europe, which is blamed on Brexit. So it may be difficult. I mean, assuming these are claims that are already in, they should still be honoured and they should still be made. One thing worth noting, though, if you have 8th directive claims, get them in now before Brexit, because obviously there's a difference between the 8th and 13th directive, and you may find that post-Brexit you're unable to make those claims.
And Glyn, sorry, what's the 13th directive?
Sorry, 13th directive claims. 8th directive claims are for VAT incurred in other EU member states, and 13th directive claims are for businesses that are not within the EU to claim. The key difference is all EU member states are obliged to offer refund to all other EU member states, but not necessarily to everybody else in the world outside of there. So certainly some countries will see the UK as not having a reciprocal arrangement initially.
Okay.
So try and get it under the 8th directive if you can. If you can't, okay, let's see what we do on the 13th.
And am I right in thinking the process itself is more cumbersome as well? For
It is indeed, yeah. So 8th directive is done through your government gateway. Very, very easy. You make it to the UK government. The UK government then goes and gets you your money. The 13th directive is a manual process whereby you then have to complete the forms in local language and attach them to the original invoices, hopefully, and send them to hopefully get your money back. Note the emphasis on hopefully.
Okay, thank you. Interesting one here. What would be the impact on consultancy services, actions and associated costs? From an indirect tax perspective, probably less so on customs, but on the VAT side.
For consultants, should remain pretty much the same. We're talking about supplies and services. Talking about supplies and services from the UK to the EU will be pretty much the same. What may be slightly more difficult will be the movement around Europe and the impact of direct taxes on people moving and providing consulting services.
Yeah, I think Glyn's made an interesting point there. It's going to be more around being able to actually put your consultants into an EU country to provide those services, and what permissions and licenses you're going to need to do that, rather than necessarily the tax impacts. And also, they're there for a long time, of course, whether they're going to create a permanent establishment for either direct or indirect taxes. And I think, if I'm right thinking, Glyn, the indirect tax bar is lower for creating an establishment than the direct tax.
There is a gap between an establishment for VAT and an establishment for direct tax, but the gap isn't that big, so care is needed. I think what it shows me really is the need to get all the taxes together on the table, because as you change one, you are going to have an impact on others.
Will EU sales lists stop being required to be completed at 31st of October?
Yes.
And will Intrastat reporting cease as well?
Yep,
Yep.
both. So there is
good news.
Yep, that's gone. No need for Intrastat if you've got customs declarations and EC sales list ditto.
Thank you. How do HMRC know how much duty or VAT to defer to a deferment account if a full declaration isn't completed at the point of entry under TSP?
That's an interesting question, and obviously still to be seen, but I would imagine it would be, even under TSP, at some stage a declaration is submitted. the information is submitted, which would then trigger the liability. So you're not doing away with paying it, you're just merely postponing it to a later date.
Could you just confirm what TSP means and what it is?
Transitional Simplified Procedures. So
Yeah.
it's basically the UK government's attempts to ease the import process from the EU to the UK by minimising the amount of information that would otherwise need to be submitted in a customs declaration, and also giving companies more time to submit that information. But it doesn't negate the requirement to submit the key information. So ultimately, at some stage, that information will be submitted and any duty and import back will become due.
Question from me, Julia. Will that have an impact on the headroom that you need in your deferment account for paying your duty on that? Because you're not going to know until 6 months, are you?
Yes. So, yeah, absolutely. You will need, that's something you will need to factor in when you are determining what appropriate duty deferment account level is.
The way that the TSP arrangement works, as of this point, but keep in mind that TSP actually has changed a little bit since it was first introduced. So if it comes in force on 1st November, we're looking at what we believe it will look like based on HMRC's official communication. Now, TSP, as it looks like right now, says that an importer can wait for 6 months, up to 6 months after 1st of November with making the full declaration. Obviously, that means that the company will have to keep track very closely of what they have brought into the country. And there might be, although it's a benefit, of course, with postponing the declaration and payment of duty, it might be a risky thing to do. So you may want to use it, but use it sensibly.
Is there any VAT change on the sale of consignment stock? So
Yes.
goods exported from the UK into Europe, held at the site and invoices used?
Yeah, I mean, that is likely now to give rise to a VAT registration in the site where the stock is held, and you will no longer be able to rely on the call-off stock simplification. I know consignment stock and call-off stock is a dual term which VAT people use the wrong way round. But yeah, the call-off stock simplification will no longer apply, and as I said, will now lead to a VAT registration requirement in country.
Thank you, Vin. We've just got a couple more questions. I hope people are finding this interesting. For UK exports outside the EU, currently we're covered by EU agreements for tariffs. Will these still be in place?
No, they won't. As one of the key impacts of leaving the EU is we also lose any access to any beneficial tariff rates when we're exporting from the EU to non-EU countries. This is where you will see sometimes government or news about the government has negotiated new free trade agreements, but as yet there is nothing in place. I think potentially something with South Korea that matches the benefit of the ones that we currently enjoy through our membership of the EU.
I think the HM Revenue and Customs have got a site, haven't they, to say where they are on the treaty negotiations of those countries.
Yeah, and that's an ongoing process, so it's worth monitoring it.
I think that's linked on the Brexit hub.
Yeah.
Yeah, and it's updated weekly. You're right, Glenn. Yeah.
This is quite a detailed one. We currently have a UK VAT number which we use to export goods in the EU. We have warehouses in Liverpool and Rotterdam. What will the customs warehouse release and VAT implications be on us? We also have an office in Ireland. If we were to register our VAT in Ireland, will we be facing the same implications as discussed? That's a long one. Sounds like you might need a written answer.
Sounds like an exam question. So, I'm just going to start off here. If you are currently if a UK company is currently exporting from the EU to the rest of the world, that's going to fall foul of the requirement that you can only be an EU exporter if you're established in the EU. So that's the first challenge I can see there. The Liverpool Customs Warehouse, there shouldn't be any issues it may be worth having a conversation with the Dutch authorities about the Rotterdam warehouse and whether that authorisation needs to be considered, because again, it could potentially be a UK company holding an authorisation in the EU, so that may need to be considered. So I think, in short, there's a number of potential issues there.
Anything to add on the VAT side?
On the VAT side, no, not really. It's mainly around the EORIs and the customs duty implications there, I think, when the issues are there. Yes, you could switch your operation to run through the Irish, but then if you've got goods coming through Liverpool, then that's not going to help. So I think as Juliet said, there's a number of complicated issues there that will come together in quite a difficult way. I suspect most of it could be sorted.
Yeah.
But I think it's a case of checking your warehouse in the Netherlands, I think, and then unpacking exactly where these goods are going and what free trade agreement you want them to go under.
And I think if I can add, that's typically kind of the complex supply chains where we need to really sit down and look for like half day or a full day, what are the full implications.
Absolutely. And things like, is the establishment in Ireland, for example, is it an actual establishment or is it a non-established VAT number? And of course, what will be the impact on direct tax and transfer pricing if you suddenly start to do more through the Irish warehouse or through the Irish VAT number?
Thank you, Lynn. We're now 5 minutes over our allotted time. We will be posting the recording of the webinar on our Brexit Hub. And also immediately after the webinar, we'll be sending you a link to the opportunity for a free consultation with our specialists. So if you'd like half an hour to talk about your specific issues, then please follow that link, provide us some information, and we will be happy to spend half an hour with you talking through some of the questions you have. Sorry we haven't been able to get to everybody's questions, but hopefully if you take up that opportunity to speak with us for half an hour, we can cover them all. It will open now, and it will open when the webinar closes. So thank you all very much for attending. Hopefully we'll be speaking to some of you again soon.